Hello YouTube. I wanted to do a video today on a book that I'm reading at the moment, and it's called, so they say you've broken the law, challenging legal authority. It's written by the Lioness. You can get this book at thelioness.co.uk. So I just wanted to read the second chapter and then give my thoughts on it. Okay, so I'm freeborn just like you. You wish to make a claim upon me. I have allegedly broken the law. Do you have proof of claim? Do you have proof of authority? If you take any action against me from this moment on, you must be certain you can answer yes to the above two questions. You will be required to in court. If the answer to the above two questions is anything other than an absolute yes, you are operating outside your professional capacity, and your actions are those of a man or woman acting upon your own liability. Your actions will be ultra vires, and you may not rely on your bond, insurance, or employer to cover you for your professional malpractice. If an act requires legal authority and is done with such authority, it is known in law as intra vires. The standard legal translation is within power. If an act requires legal authority and is done without such authority, it is known in law as ultra vires. The standard legal translation is beyond power. Do not proceed unless you are certain you possess the foundation evidence for your claim, because I shall summons it in court. You will be committing a civil crime, a human against human, of tort, including but not limited to the breach of a duty of a care, a wrongful trespass against me or my property, assault, battery, false imprisonment, evasion of privacy, tortious interference, fraud, tort conversion, intentional infliction of emotional distress, invasion of privacy, abuse of process, malicious prosecution, and ultimately aggravated damages of malfeasance in public office. I have not had sight of proof of claim nor proof of authority. I believe no such proof exists. Make no mistake, in this civil matter, I will sue you personally, not the employee uniform status you may imagine will protect you. Okay, so we're going to see what is proof of claim and proof of authority. Okay, now first, in the first line, it says, I've allegedly broken the law. Let me zoom in and zoom out so I get it. Okay, I've allegedly broken the law. Okay, now it's important to note that it's always an allegation that they put up against you. It's always an allegation because they make presumptions. Okay, when it comes to statutory law, they always make presumptions you are subject to statutory law, which is why they always allege that you were offended. There's no crime. There's never any crime. Okay, not a real crime. For there to be a real crime, there has to be a corpus delicti, which is a body of a crime. There has to be a physical object which has been damaged, that you can see has been suffered from damages. So if you break someone's stuff or you actually damage a person, okay. So they always make allegations, presumptions, and my favourite that I get from the police is "we have reason to believe." That's always a good one, a standard one that they do. Okay, so do you have proof of claim? Okay, what is proof of claim? Now, proof of claim is if you got stopped and you got a ticket for a Road Traffic Act violation, okay, the claim would be that you offended. They would allegedly say that you offended the Road Traffic Act. The proof of claim would be the document that would tie you to be subject to the Road Traffic Act. Okay, now for a lot of private individuals, I can't really think of a document that would tie them to a statute, except for like if you're driving a DVLA car. I suppose if you're driving a registered DVLA car, you would be subject to their rules and regulations, because you would be operating, or at least stating, self-witnessing that you're operating in trade or commerce. But for say the police, for example, okay, if you put them on the bench for a road traffic violation and they said, where is the proof of claim? Okay, first you added their oath of office, so the constable's oath. So they take an oath to the crown, so they're subject to the crown. And then on top of that, they're working as agents for the UK corporation or the Crown Corporation. So they're acting as agents for the crown, so they're subject to the crown. And then they're getting paid for the job that they're doing as well. So they're operating on trade on the roads or commerce on the roads. So they would have proof of claim. For a private individual using the roads, I can't imagine any proof of claim that would tie them to a statute. Okay, Secondly, do you have proof of authority? That's a proof of claim that gives them the authority. Okay, so if you damage someone, we the people hire the police to protect the people. So if you damage one of the people, then a policeman has the authority to stop you and arrest you and detain you if need be. Now this is where the key stuff comes in. Proof of claim and proof of authority, which is the foundation evidence. Okay, now foundation evidence is a legal argument because the whole case has to sit on a foundation, and that would be the foundation evidence. The proof of claim tying you to subject to the statute, and the proof of authority. Okay, so where did they derive their authority from? And this is where I personally think a lot of people are going wrong with the whole consent thing. Because say, for example, they're saying, I don't consent, I don't consent. It would be better to ask them where the proof of consent is. So where is the evidence that you've consented to dealings with the corporation? Because the burden of proof is always on the claimant. It's never on the defendant. Okay, so if you're saying I don't consent, then you're making a claim, and when you're making a claim, you're the one who has to provide the evidence. Whereas if you ask them where is the evidence of my consent, okay, because you are alleging that I've offended something, or you're making an allegation or a presumption, then the burden of proof is on them. And it's important that when we go to magistrates' court as well, the only thing the magistrates care about is the evidence on both sides. And if you can't show that there's no foundation evidence, then their evidence wins because you haven't challenged the evidence. You haven't challenged the foundation of the evidence. So their evidence does win. Okay, so the next point is them acting out of their jurisdiction. So as soon as you've let them know this, and they know there's no foundation evidence for the case, and they carry on with it, then what they're doing is they're personally offending you. They're going out of their way to give you damages. No matter what it's for, they might not like you. They might just think that they're doing their job. They might have targets to hit, like some of them have targets to hit. So that's always, the next thing is acting out of jurisdiction. So it's ultra vires, acting out of jurisdiction. And when they act out of jurisdiction, okay, when you're a private individual and they become a private individual because they're dealing with a private individual because you've let them know, okay, that there's no foundation evidence for this case, or you've asked them to prove it and they have no foundation evidence for the case, then what they're doing is committing a civil, they're creating a civil dispute. And police know that they shouldn't create civil disputes. That's one of their lines they love to drop on people, which is, they always say, we can't get involved in civil disputes. So they're creating a civil dispute, okay, when they're acting out of jurisdiction. And when they're creating a civil dispute, they're personally liable. So they do commit the civil crime. It's a civil crime and you take them to civil court. You won't get remedy in magistrate's court. The best remedy you can get in magistrate's court is a strike or a dismissal or a discharge. Okay, I've seen in the manual they do discharges. So that is the best remedy you can get because it's not our court. That's their court. The only thing they care about is if you offended the crown or not. Okay, so you're there to challenge the evidence of the prosecutor. You're not there to tell them what your position is or what your power is. No, you just challenge the evidence of the prosecutor. Okay, as the defendant. Okay. So yeah, that's really the sum up of it. I might do another chapter later or another time and just do a bit more explaining into proof of claim, proof of authority, and consent. But at the moment, instead of saying I do not consent, try and stick to where is the consent, where is the foundation evidence, where is the proof of claim, where is the proof of authority. Where did you get your authority from, officer? Who's making a claim? Where's the proof of claim? Where's the corpus delicti? Where's the foundation evidence? That's the biggest one, foundation evidence, because it covers everything. Okay, and that's, if you go to magistrate's court and you ask for the foundation evidence of a case and they continue the case and just ignore your discovery for foundation evidence, then that's a, where is it? It says here, abuse of process. There it is. So that's abuse of process. Okay, So when you go to magistrates court, you get their names down on the record as well. You make your own record, you get their names down. And to be honest, I don't even think they'll, if there's no foundation evidence, it's really just common sense. If there's no foundation evidence, the case has to be dismissed, because you can appeal it and it'll go to a higher court. And if there's no foundation evidence there, they'll dismiss it as well. So they say you've broken the law, challenging legal authority, Sarah Lioness, or The Lioness. You can get this book from thelioness.co.uk, and it's a good buy. It's only a thin book, pocket book, 50 pages, a lot of good information. It's got some template letters that you can send to public officials as well. So definitely recommend it, and I'll probably read another chapter another time. So see ya, nice one.